Good afternoon and welcome to our revision tutorial session. I presume that at this stage you have essentially finished all your revision and you are just doing a mopping up. I have few friends who privately asked me to not to discuss any substantive things as I am doing, but to give them advice on do's and don'ts as they get ready to sit for the paper next week, I suppose. Well, as I have told you before, respect rules of the game, respect the instructions on the question paper. If you are supposed to answer 4 questions, don't answer more than that. So that is the first thing you have to keep in mind. And number 2, you have to remember that the questions have been allocated marks, and regardless of how brilliant or excellent you think you have responded to the question, you cannot be given more than the maximum marks allocated to that question. Point 3, you have to, of course, so related to that, so the implication is that if a particular topic you know so well has been examined as you having a particular question on it, don't be carried away and spend half of the time answering only one question when you have 3 other questions unanswered. Now, when you do that, you will finish the exams, go out of the exam hall, having that illusion that you have really done the paper well and there's no way that you fail. The results will come and you will not have made it. You have failed. Why? Because you might have made, let's say, 21/25 or 23/25 for that particular question. And all the other questions, you're probably getting 5, you're getting 3, 6, or 7. So despite the fact that you have excelled one particular question, the other 3, you didn't do that well. So it's going to let you fail the entrance examination for that particular year. And that is why we are saying that you have to be balanced. Okay, you have to be balanced. All the 4 questions you have to choose and do, they are equally important and they all count towards whether you pass or you fail. Good. So these are basic things you have to keep in mind. And other thing to remind you again, and I think these tips, as and when I'm able to come online and engage you, I'll be reminding you until you go to do the exam. The other thing you have to keep in mind is that don't make it difficult for your examiners to see what you are writing, okay? Try and be clear and legible as possible. And also, you are writing a law paper, okay? And mind you, you have already gone through the course. It's not that you are not learning the course. You have gone through the course, you have passed the course already, and your various universities have certified that you have attained Bachelor of Laws degree or LLB in the respective courses put together. Therefore, being a law paper, it will be worrying if you answered a question without supporting your arguments, your discussion, or whatever with the relevant legal authority. That is to say that if we have relevant statutory provision or constitutional provisions or decided cases, you must use them to buttress your discussion, your argumentation. So your responses should be grounded in law. So that is one thing you should keep in mind. And on that too, the other advice to give is that when we say that you should cite authority, when we just state authorities without letting us know the statement of the law, the proposition of the law, you haven't also done well. So you should be able to tell us in a topic sentence form, in the statement form, what the relevant principle, the proposition is, before you indicate the case or the particular authority which support or out of which that principle, for example, emanates, as it were. So let us keep that in mind. And it will not be out of place if you can also let your authorities stand out in your answer. If you're able to do that, that is fine. But if you're not able to do that, it doesn't really spoil much. Because except that where you have your authorities really standing out and your examiners are reading your script hurriedly because they mark under pressure, sometimes becomes convenient for them. So that is one thing to probably also keep in mind. And of course, another thing which really incur displeasure or disaffection of examiners is where you do not make effort to use effective English language, use good grammar. There are certain language errors or mistakes we don't expect at this level. So please pay attention to that. Yeah, so as we move on, we will be telling you more about the do's and don'ts. But of course, one big do's and don'ts is that being a law paper, if you have a problem-based question, you must use the structured approach, the IRAC or the IPAC, and don't just start writing in a journalistic fashion. So let's keep that in mind. So with that said, we come to theme number 3 of our revision of contracts. So we are looking at vitiating factors, namely mistake, misrepresentation, duress, and undue influence. But maybe just before I do that, with respect to the do's and don'ts that I just recap for attention of those who privately requested me, if there is anything relating to the exams which you want me to comment on or you want me to give some advice, please feel free and do that now. So I'm pausing for a minute. You can just use the chat to raise up your hand and then I'll allow you to speak. Is there anything? Okay, I haven't seen anything yet. All right. Okay. So before we recap principles under this topic, I have some preview questions. On Saturday, Peter placed an advertisement in a local newspaper offering his Ford cereal for sale for 250,000 Ghana cedis and providing his telephone number. That evening, Peter received a telephone call from Bill, who, impersonating a well-known television and state personality, Ronnie Parker, agreed to purchase the car. Bill, using the assumed voice of Ronnie Parker, stated that he would send his chauffeur to collect and pay for the vehicle. The following day, Bill visited Peter's house, claiming to have been sent by Ronnie Parker. Peter handed over the car in exchange for a check for 250,000 Ghana cedis. Signed, R. Parker. Bill then requested that Peter sign a document which stated, "Received of R. Parker, a check for 250,000 cedis," which Peter read and signed. Before leaving, Bill presented another document to Peter, representing it as a mere copy of the receipt for Parker's records. Without reading it, Peter signed this document, which was in reality a guarantee of Bill's debts up to 350,000 Ghana cedis in favor of Tom, a tradesman. On Monday, Bill sold the car to Doris for 50,000 cedis, and by showing the guarantee signed by Peter, persuaded Tom to extend him credit for goods worth 50,000. Peter now seek advice on the following issues: whether Peter can recover the vehicle from Doris, considering that she purchased it from Bill in good faith for value. And two, whether Peter is legally bound by the guarantee signed in favor of Tom, despite the circumstances under which it was signed. Okay, so we have these questions, and yes, can we try it? Well, since it's a preview, we're actually going to discuss the topics relating to this misrepresentation, the rest of the universe. We'll just keep the questions in mind. Depending upon time, we may come back to them after the revision and discuss them, but just to give you a preview of how these areas can be examined. Question 2. In June 2020, Sarah and Liam were negotiating the sale of Liam's art gallery to Sarah. Liam assured Sarah that the gallery was in perfect condition and that all necessary repairs had been carried out recently. In truth, the gallery had serious structural issues that Liam was aware of, but he chose not to disclose them. Liam also stated that the gallery had a consistent flow of high-end clients, which was true at the time. Let me open this up so that it's bigger. Yeah, so you can take pictures of the questions, okay? You can take pictures of the questions with your phone so that you, later on, we are discussing them. You have like the questions and you're able to make reference to them. Okay, so let me move on to the next one. Thinking you've taken the pictures if you want. Yeah, so I start the question 2 again. So in June 2020, Sarah and Liam were negotiating the sale of Liam's art gallery to Sarah. Liam assured Sarah that the gallery was in perfect condition and that all necessary repairs have been carried out recently. In truth, the gallery had serious structural issues that Liam was aware of, but he chose not to disclose them. Liam also stated that the gallery had a consistent flow of high-end clients, which was true at the time. Sarah purchased the gallery for 500,000 cedis. After the purchase, Sarah discovered the structural issues and had to spend 100,000 cedis on repairs. Despite the repairs, the gallery was less profitable than Sarah had anticipated, partly due to a new art gallery opening nearby, which Liam had known about but did not mention. Advised Sarah on her legal position regarding the purchase and the possible remedies available to her. So if you get a scenario like this, it certainly provoke issues from certain areas of the law. So keep them in mind. We'll be getting back to them very soon. But take a picture of this screen. Step 3, Mark, a successful entrepreneur, wanted to expand his business by acquiring a well-established restaurant. He found one owned by Joan, who claimed that the restaurant was highly profitable, with a steady clientele and an excellent reputation. Joan also stated that the restaurant location was prime for attracting tourists. So Mark, relying on Joan's representation, purchased the restaurant for 700,000 cedis. After taking over, Mark discovered that the restaurant's profits had been declining for the past year and that the location was not as advantageous as Joan had claimed. Additionally, a major road construction project nearby had severely impacted foot traffic, a fact that Joan was aware of but did not disclose. Advise Mark on whether he has grounds to rescind the contract or claim damages based on Joan's representations. Okay, so that is another question from the area of misrepresentation, as we'll be discussing. So take a picture of it. 4, in April 2017, Lucas, a car enthusiast, negotiated with Karen to buy a classic car. Karen told Lucas that the car was in mint condition and had never been in an accident. Lucas, rely on Karen's statement, purchased the car for 80,000 Ghana cedis. Shortly after the purchase, Lucas discovered that the car had previously been involved in a serious accident and had undergone significant repairs. The car's value, given its history, was actually only 50,000 cedis. Lucas also learned that Karen had purchased the car knowing about its accident history, but had concealed this information during the negotiation. Advised Lucas on his legal rights and potential remedies. So you have to remember we are still dealing with misrepresentation, silence. We'll be discussing that very soon when we are revising the topics. Question 5. So take a picture of this screen too if you want. Question 5, Rachel, who owns a small chain of boutique hotel, was looking to purchase another hotel to expand her business. She found a hotel in a popular tourist destination and contacted the owner, Paul. Paul assured Rachel that the hotel had high occupancy rates and was a profitable business. However, Paul failed to disclose that the hotel was facing a significant lawsuit from a guest who had been injured on the premises. Okay, before I continue, somebody wants to take a shot of and he or she missed it. So I've gone back. You can take the shot of the question too. And then I'll continue. Okay, so let me continue. Rachel purchased a hotel for 1.2 million cedis. After the purchase, Rachel discovered a lawsuit which had resulted in substantial damages award against the hotel. The hotel's profitability was also significantly lower than Paul had represented, partly due to negative publicity from the lawsuit. Advise Rachel on whether she can rescind the contract or seek damages from Paul. Okay, so still in the area of misrepresentation. Question 6. David, an art collector, was interested in purchasing a rare painting from a private seller, Alice. Alice assured David that the painting was an original work by a famous artist and had been authenticated by experts. Relying on this, David purchased the painting for 200,000 cedis. After the sale, David had the painting appraised by another expert who informed him that the painting was a well-crafted forgery, worth only a fraction of what he had paid. Alice insists that she believed the painting to be genuine and had no intent to deceive David. Advise David on legal options available to him. So still in the area of the misrepresentation. So take a shot of the screen if you want. Seven, James, a successful businessman, was approached by his nephew, Martin, who was in desperate financial trouble. Martin pleaded with James to guarantee a loan of 500,000 to help him avoid bankruptcy. James initially refused, but Martin, knowing that James was sensitive about family matters, told him that if he didn't help, it will ruin the family's reputation, and he might never be able to forgive him. Under immense emotional pressure and feeling obliged to protect the family's honor, James reluctantly agreed to guarantee the loan. So please take the shot before I continue. Unfortunately, Martin defaulted on the loan, and the bank is now seeking to enforce the guarantee against James. James feels that he was unduly pressured into agreeing to the guarantee and now wishes to challenge his enforceability. Advise James on whether he has a legal basis to avoid the guarantee on grounds of undue influence or duress. Pretty straightforward. Question 8. Sophia, a 75-year-old widow with little business experience, relied heavily on her neighbor, George, who was a retired financial advisor, for advice on financial matters. George had always been friendly and helpful to Sophia. One day, George convinced Sophia to sell her house to him at a price significantly below market value and suggested that it was the best way for her to avoid financial trouble in the future. Trusting George, Sophia agreed and signed the contract. Sophia later discovered that her house was worth much more than George had paid. and that she could have easily managed her finances without selling the house. She now wishes to challenge the sale and argues that George unduly influenced her to agree to the contract. We are to advise Sophia on whether she can have the contract set aside on grounds of undue influence. And then the last one, question 9. Karen was a young entrepreneur who was negotiating major business contracts with a large corporation, ABC Limited. During the negotiation, the representative from ABC Limited, Mr. Brown, hinted that if Karen did not agree to their terms, they will make sure a company will be blacklisted in the industry. Feeling intimidated by the threats and believing that her business will be ruined if she refused, Karen reluctantly signed the contract on the terms that were highly unfavorable to her company. Afterwards, Karen began to question validity of the contract. Advise Karen. Yeah, so if you are able to work yourself through these questions, then I'll be confident to propose to you that there's no question on vitiating factors which you will not be able to answer. Good. So vitiating factors refers to those matters which actually affect validity of the contract and will render the contract unenforceable. Because the bottom line is that before you can have a valid and enforceable contract, the parties must have genuinely and voluntarily given their consent, meaning that if there is any evidence which suggests that in law, one of the parties or both parties did not truly consent to the terms of the contract, then the contract is said to lack validity. So its validity is vitiated or is defective. So question arises, what are the things which will actually affect the consent of the parties so that a court will come to a decision that yes, the consent which was given is not a valid consent? Well, we know that those factors which are called vitiating factors include mistake, misrepresentation, duress, and then undue influence. And where they are present, they affect the validity of the contract, and it may render the contract either completely void or voidable, depending upon whether you're looking at it from the point of view of common law or equity or the particular type of vitiating factor that you are looking at. So we know mistake, but as far as mistake is concerned, we are not talking about it in the sense of a layperson's understanding. Now, if you talk about mistake, which will actually render a contract invalid, so to speak, it must be operative mistake. And operative mistakes refers to an error or mistake concerning a fundamental fact, which must be of such significance that it affects the very foundation of the contract. So if there is information, a factual information, which goes to the very root of the contract, and someone entered into the contract with misapprehension or misunderstanding as to that, then we can say that the person entered into the contract having a certain mistake operating on his or her mind. So you may want to find out why will mistakes, like, there are a lot of mistakes which will not invalidate contract, or we've made the point that it's not the layman's understanding of a mistake, which is important for us. Well, the courts are ready to enforce what they call apparent agreements. When we say apparent agreement, remember that we said from the beginning dealing with the formation of contract, that the test of agreement is objective. That is apparent. That is, if from the point of view of official bystander, a third party, reasonable third party, it appears that a certain agreement has been made by the parties. The court will agree that yes, an agreement exists. So that is the apparent contract, apparent agreement. So where there's an apparent agreement, then the courts are prepared to enforce it on the face of it, as it were. And again, another reason why the courts are not excited to be recognizing mistakes, lightly as invalidating contracts is that the courts do not want a situation where third parties, will have their rights unnecessarily interfered with through circumstances in which they are completely ignorant or innocent. So protection of third-party rights, another reason why the courts do not want to recognize all manner of mistake, so to speak. And of course, we also know the caveat what enter. Let the buyer be aware, as you know from a commercial law or sale of goods, that when you are going to buy something, mistakes which are actually patent, which are appear. You don't need any serious examination to unearth it. You take responsibility for identifying them. Otherwise, if you make a wrong assumption about the quality of the subject matter and say that I thought it was like this, nobody would actually entertain. But of course, we are aware of the various qualifications in the Sale of Goods Act regarding certain protection which the law gives when it comes to various types of mistake relating to like the quality of the item being sold in the contract for sale of goods. Yeah, so those are the basic reasons why the courts are not eager to easily recognize a mistake, and it must be an operative mistake which will be entertained as actually rendering the contract invalid. And again, we must remember that by the mistake, we are talking about mistake of fact, not mistake of law. And we know that the law says that ignorance of the law is no excuse. All of us are presumed to know the law. So you cannot say that, oh, when I entered a contract, I thought that this was the legal position when I was rather mistaken. No, that is not what we are talking about. We are talking about mistake which relates to facts and not a point of law. And you know the case of Saul and Bacha, where there was a mistaken belief that as to whether the Rent Act applied to a property, because its identity was thought to have changed due to innovation. But the court did not recognize that as a mistake of fact. The court regarded that as a mistake of not as a mistake of the law, but as a mistake of fact. There was that kind of misapprehension as to whether a particular property, because of a particular state and subsequently it was renovated, whether the Rent Act applied to it or not. And the court said that yes, yes, mistake is about mistake of fact and not mistake of law. And for that matter, it was consistent with the position of the law that the operative mistake which can upset a contract is one which relates to facts and not mistake as to law. We know there are three main types of mistake. We know common mistake. Common mistake, that is where both parties have made the same mistake, so to speak. Both parties share the same erroneous belief about a fundamental fact related to the contract. And we have a distinction between how the common law approaches this mistake and how it is approaching equity. At common law, where there's a common mistake, we say that the contract is void if it relates to res extincta. Res extincta simply means that if it's about existence of the subject matter, res refers to a thing or a subject matter, and extincta, that is a non-existent. So if the mistake relates to existence of the subject matter, so that both parties at the time that they made the contract thought and believed that what they had contracted about existed, when as a matter of fact, what they contracted about did not exist at the time that they were even making the contract, then the mistake is made. Both parties made a mistake, and that is why I said there's a common mistake. And what type of common mistake? A common mistake relating to existence of the subject matter, res extincta, as happened in the case of a cultura against a hairstyle. And where that is the case, then the position of the law is that the contract is void. Cultura and hairstyle, if you remember, there was a contract for the purchase of corn, which was expected being shipped from the high seas, not knowing that in the course of the voyage, conditions had deteriorated, and the master of the ship had made a decision that it should be disposed of at available markets. But the seller and the buyer at the destination of the ship, waiting for the cargo to arrive, had entered into contract, knowing that there was this thing which was coming. When at the time of making the contract, the thing had already been disposed of, unbeknown to the parties. So the court said that yes, both parties had made like the same mistake relating to existence of the subject matter of what they are contracted about. That is the con. So there was no contract. Then we also have but of course, let me qualify this and say that when it comes to sale of goods contract, okay, under Act 137, Act 137, the Sale of Goods Act, there is a implied obligation on the part of the seller that when it comes to the sale of a contract when it comes to the contract for the sale of a specific good, that the good is in existence at the time that the contract was made. So that is a qualification to this. And if you were in the maybe first year we are teaching you contract, probably not tell you because you know have done commercial law, but now you have finished all these areas of the law. So when you are discussing matters in which you have to bring other areas of the law which are relevant, you must do so. And here's an example. So if you go to sale of goods law, when it comes to specific goods, and somebody will ask, what is a specific good? What are specific goods? Well, under the Sale of Goods Act, specific goods are goods which have been identified and agreed upon by the parties, either before or at the time of making the contract. So for example, if we enter the contract to buy your phone, right? If that will be considered as a specific good, because all of us will have agreed that it is this phone which is being sold or which is we are negotiating to buy and sell, as it were. So that's a specific good. So when it is specific good, then the common law position that we have said will not apply, because there's a statutory obligation that you as a seller, you are making a solemn statement, or you are making, you have an obligation to ensure that the specific good is in existence at the time that the contract was made. And it makes sense. Otherwise, it would defeat the concept of specific good. If specific good is an item which has been agreed and identified by the party at the time that the contract was made, then naturally, there should be no claim that at the time that the contract was made did not exist, as happened in the case of Kultura and Hester. We also have common mistake that we treat as a restaurant, and this involves a situation where a person contracts to buy something they already own. So if maybe you're owner of a something and there's somebody who asks, how can you know that you're owner of a something that you don't know that you're the owner? Well, that's happened in the case of a Cooper and Fitz, as you notice. An inheritance will be given to someone, and the person was not aware that by reason of that, he was like the owner, and then went ahead to continue to have the thing leased to him. And then the court said that the person had entered into the contract thinking that he was not the owner, as it were. So that would you can certainly not enter into contract to buy that which already belongs to you. It doesn't make sense. So that will also operate to void the contract at common law. They will also have a common mistake as to quality. It's often debatable as to whether if the parties had a common mistake, they have made the same mistake regarding quality, whether that can void the contract. And typically, the case of Bell and Liver Brothers, if you remember, where there was a senior employee, the managing director, that the company had entered into agreement for him to leave the services. But later on, the company discovered evidence which suggests that at the time that they entered into the compensation agreement for him to peacefully leave the services of the company, they could have actually dismissed him without even going through that kind of mutual agreement for termination with him. Yeah. And in Bell and Liver Brothers, Lord Atkin, that's a yeah. So in Bell and Liver Brothers, Lord Atkin noted that a mistake about equality might be fundamental if it concerns equality so essential that its absence makes the subject matter fundamentally different from what it was believed to be. So trying to set the test that, okay, before we can consider mistake as equality as being the type of mistake which can render a contract void, then we need to find out was the particular quality which both parties are said to have mistaken about. Was it so crucial? Was it so foundational that if the particular thing that you're contracting about, if it doesn't have that quality, then it will be worthless. It will not be worth whatever. So if that is the case, then that could serve as operative for mistake. And then he gave like the illustration from what we know from what happened in the case of a leaf against the constable. For example, that if a buyer purchases a painting, believing it to be the work of a master, but it turns out to be a modern copy, then the buyer will have no remedy unless there was a misrepresentation or so just illustrating that yes, before we can entertain any claim that both parties honestly mistaking the quality of what they had contracted about. And for that matter, they should be released from any obligation, or we should say that no contract really existed because their minds actually did not meet and so on. We must ask ourselves, the particular aspect that they are saying they are mistaken about, was it that major? Did it go to the very heart of what they were contracted about? If the answer is yes, then that could serve as an operative mistake. But as we know, equity is more elastic or flexible as it were than the common law. Common law, where it is established that yes, a common mistake operated automatically, it will render the contract void. Void ab initio. Void ab initio means that right from the moment that the contract was sought to have been made, in the eyes of the law, no contract existed, so no rights actually were created or can be asserted under it. However, equity takes a very lenient and flexible approach. And in some cases, where even a common mistake has been established, depending upon the circumstances, equity may say that, yes, it is voidable. That is to say that it remains valid until it is set aside by a party who is affected or who is complaining of such a mistake, as it were, in which case the remedy of rescission may be given or some other remedies appropriate to the particular circumstances of the case that you have in hand may be given. So let us look at that. So if you look at the Soul against Butcher, for example, or Butcher, where there was a mistake regarding the property as to whether the rent legislation applied, after the renovations and all that. The court was prepared to grant a rescission, but it also granted it on terms. It allowed the tenant to remain at the maximum permissible rent. That is to say that the contractual rent is not that which was actually used by the court, but having regard to the renovation and the provisions of the Rent Act, under the law, the maximum rent which will be given under it is that which was said to be payable and not what the parties had agreed. Because even when they made the contract, as we have noted, they both made a mistake as whether the Rent Act applied to the property in view of the renovations which are taking place. So let's keep that in mind. We also have a mutual mistake. Mutual mistake, as the term suggests, both parties are mistaken. Of course, then some will say that how different is it from a common mistake? Yes, common mistake to both parties are mistaken, but the mistake is about the same thing. But the mutual mistake, both parties have made a mistake, but each party has made a different mistake. So both parties are mistaken, but the mistakes are not the same. So there is what we call the mistakes are pointing in different direction as it were. I would say that they are not consensus what adhere them. So at common law, a mutual mistake does not automatically render the contract void. The court will need to apply the what we call the objective test. Objective test to find out whether, considering the words the parties said to each other or the things that they did, or whatever that they exchanged, whether it can be said that there was an agreement between them. If there was an agreement between them, then despite the fact that in their individual minds, they thought differently. The court will ignore what their subjective intentions were and give effect to what appears to have been the agreement using the using the objective test. So if a reasonable person would discern the existence of a contract, the court will say that, yes, there's a contract, despite the fact that one party or the other believe differently, as it were. So it is only where the court cannot actually establish a sense of agreement, say that there's an apparent agreement using the objective test, before the court will conclude that there's no contract, the contract is void. So we need to contrast the case of Wood and Scott with the case of Raffles and Wichelhurst. In Wood and Scott, for example, there was a misunderstanding. If we look at the red judgment about £500 premium payment. But the court did not recognize that as negating the contract, because the plaintiff reasonably accepted the defendant's offer based on its clear terms. So the court used objective tests to say that when the plaintiff accepted the offer, he had accepted it according to the defendant's terms and not any other. So the court used like the objective test. But if you look at the Raffles, which many of you know too well, a very well-known case, you know, like the two shifts, which were supposed to carry cotton, and the two shifts had the same name, PLS, but they had the same name and they came from the same destination, Bombay, but they move at different times. I think one moved in October and the other one in December. So a contract was made, and one of the parties thought that the cotton which they are contracted about was going to be delivered by the ship, the PLS ship, which will come in October. And then the other thoughts, the seller thought that, no, I'm expecting that which will arrive in December. So you notice that the offeror has made an offer, thinking that cotton being sent by a ship coming from a particular date is what was being offered. And the other party, the offeree, also accepts, thinking that he was accepting cotton, which was to be arrived by the same ship in a different month. So there was what we call the lack of consensus. So there was no consensus added them. An objective test, for example, could not help the court to discover sense of agreement. So the court said that the contract is void. But what I want us to pay attention to is the fact that the court does not just jump to the conclusion that because there's a mutual mistake, automatically the contract is void. No. The court would deploy the objective test if it is unable to actually determine any agreement using the objective test before it will say that the contract is void. Again, how equity approaches the matter is that, as we often know from the maxims of equity, that equity follows the law. That is to say that where the law is giving results which are reasonable and fair, equity will not interfere. So in the same way, equity too will seek to ascertain the true intent of the agreement using the same objective test. And equity will go about it in more or less the same way as the common law will go about it, using the objective test as it were. And that is why in the case of a Tamplin and James, you know very well about the auction, where a property was being auctioned, the person who went to buy it at the auction was too familiar with the property. And then he decided to ignore the brochure or the documents containing information about the property because he thought that he knew the property so well. But then when he actually had the property given to him and he had to pay, he realized that what he had bid for was less than the extent of the property that he knew, which he took for granted, and he did not read the document governing the auction. And the court said that yes, if you look at the scenario and you apply the objective test, there was a contract because if you use a reasonable man position, the objective test, anybody who attended the auction would definitely assume that it was the information contained in the brochure or the document which was telling us about what was being auctioned. So if you chose not to read it, but you just went ahead and made a bid, then you cannot say that I thought I was bidding for something different from that which is contained in the document. We also have unilateral mistake as another type of a mistake which you know very well. So unilateral, that is to say that only one party has made a mistake about fundamental fact, another party is or should be aware of this mistake. So the other two, both parties have made a mistake, as we saw. The common mistake, both have made the same mistake. Unilateral mistake, both have made different mistakes. But unilateral mistake, only one party has made a mistake, and the other is aware or is supposed to be aware. And typically, when it comes to unilateral mistake, we often encounter it in relation to what we call identity of the other contracting party, so to speak, identity of the other contracting party. So where you make a contract with A, thinking and believing that it's A that you've made a contract with, when as a matter of fact, you contracted with B, and B knew that he was not the one that you entered to contract with, but he had presented himself as A. So that is the kind of scenarios that we are talking about. So at common law, the presumption is that the contract is valid. That is, if a contract is made and you are alleging unilateral mistake regarding that contract, the starting position is that that contract will be upheld as valid. So there's a presumption of valid contract regardless of the unilateral mistake, unless the party pleading mistake, the party who's alleging to have entered into the contract as a result of mistake, can prove the following. One, that they intended to contract with someone other than the person they apparently contracted with, that I've contracted with B, but it's not B that I wanted to contract with. I wanted to contract with A. If you can show that, then that is fine. But you haven't finished. We need to show, secondly, that the other party was aware of this intention. So that is to say that you've entered in contract with B, but B ought to have known that he was not the one that you wanted to contract with. It was A you wanted to contract with. So you must prove that. You have the burden of proof. And again, that you took reasonable steps to verify the other party's identity. So before we can be convinced that you actually, considered the identity of the one that you're contracting as really important, you need to prove that you did something to verify the other party's identity. So yes, you've contracted with B, but how can we be sure that it was not B that you wanted to contract with, but A? You need to show that you did something at the time of making the contract to verify that it was A you're contracting with and not B, just that you happen to have contracted with B due to the fraud or the craftiness of B. as it were. Yeah, so as I said, you need to show that the identity of the contracting party was of fundamental importance. So what shows that the identity of the one you're contracting with is important? What shows? So as you look at the case of a case Norton Meta against Edrich, all these tests were actually propounded over there. But as we noticed, the test was not met in that particular case, despite the fact that the rogue, that is the fraudster, they pretended to be a different entity. But as to whether the requirements that we mentioned have been met so as to enable the court to uphold the plea of natural mistake as to identity of the other contracting party, it would depend very much on whether the parties dealt face-to-face or they did not deal face-to-face. Where they did not deal face-to-face, we say that they conducted the business or the transaction in inter absentis, and that at a distance. Maybe the offer was sent by maybe a letter, acceptance by a letter, or some other means. The parties were not standing physically together. Or if they dealt face to face, in which case we call it inter presentis. So the position of the law in terms of the burden of proof as to whether the identity of the contracting party was really important, how that is shown varies. It is more stringent where the parties dealt face to face than where they dealt inter absentis. That is to say that it is relatively easier for the court to hold that a contract alleged to have been contracted as a result of unilateral mistake as to identity is voidable. Where the contract was made inter presentis, it was made face to face, as happened in the case of Candy and Lindsay, which you all know very well. So that was the inter presentis, inter absentis. As you know, the rogue, he used the letterhead, right, of a famous business, and he used it to order for goods. The goods were sent, and later on he paid by a check, which was dishonored, and by which time he has sold the goods to a third party. So the company which had actually sent the goods later on traced the goods to a third party and sought to recover it. But as whether it will be able to recover it or not, depending upon whether title, that is ownership in the original goods, whether it had passed from the original owner to the rogue, that is the fraudster. If it had passed from the original owner to the rogue or the fraudster, then the rogue or the fraudster could have also passed a good title, good ownership to the third party, in which case the third party will become like the new owner, and the original owner cannot recover it. But in this particular case, the court took a view that the rogue had not succeeded in getting a valid title, and for that matter, he could not have transferred title to the third party. As we know, no that could not have it. You cannot give what you do not have. On the other hand, where the parties did not deal inter absentis, that is not at a distance, but they dealt inter presentis, that is face to face, there is a stronger presumption of intending to contract with the person physically present. So in that case, supposing you have like a shop and someone entered the shop to buy things on credit and so on, and even told you that, oh, I am now, who is some of the well-known, okay, let's say a spouse. there's this guy, Asamoah is always like in the news as a certain sports celebrity. Good, let's go as an example. So the person comes and then he tries to present himself, for example, as the one, and he said that, oh, take the check for all these goods and so on. So you collect the check, you give the goods to him, and later on, you present the check for encashment and the check is expanded. And you just realize that it was not that Asamoah, but just someone who had actually impersonated himself. So that is a typical interpresentis face-to-face. And for that, the position of the law is that there's a strong presumption that you intended to contract to the person who physically appeared. So it does not matter that you said it was Asamoah. The human being who entered the shop was the one that you intended contract with. Of course, as I said, it's a presumption, so it can be rebutted, but a very strong presumption, and it's very difficult to rebut it when you are dealing face to face. And that is why in cases like Phillips and Brooks, the case of Lewis and Ivory, Shogun Finance and all that, the court will hold the view that where a contract was made interpresented with a rogue, a supposed rogue, the contract is still presumed to be valid and be given effect to, because you intended to have actually contracted with the person who was actually present when the contract was made, and not whom he represented. Again, we can also have a unilateral mistake as to the nature or the quality of the offer, and a mistake as to the nature of the offer may be considered void if the mistake is apparent or should have been apparent to the other party. So here we are not talking about identity. We are talking about the quality of the subject matter of what was actually contracted, as we see in the case of Hartog against Collins and Shells. And over there, as you notice, the contract was held void when hair skins were mistakenly offered at the price per pound instead of per piece. So per pound and per piece, they are different. And the quantity-wise, per pound will be more, and then the per piece relatively small. So the court upheld that mistake which the other party had made in making the transaction as being operative one sufficiently to make the contract void. Now, when it comes to equity, the approach to unilateral mistake is not very different. Equity would allow for rescission where you're able to establish that a contract was made as a result of unilateral mistake. Or, in appropriate cases, equity may refuse the grant of specific performance if equity is satisfied that the other party entered into the contract as a result of unilateral mistake. Of course, all the things that we have said are applicable as whether the contract was in inter absentis, they dealt remotely, distance from each other, or they dealt face-to-face, inter presentis. If they dealt face-to-face, as we have noticed, there's a strong presumption that you intended to enter the contract with the person who was physically before you and not whoever he represented to you as being. So let's keep that in mind. What about where a person has signed maybe a document mistakenly? We've made this already when we were discussing terms of contract. The famous play of a non-S factum. So where you have signed a document mistakenly, the play of non-S factum, that is not my date, will allow you to avoid the contract if it was signed under fundamental misunderstanding of its nature. So in that case, if it operates, it will operate to make the contract void, where it can be shown that the document is fundamentally different in character from what the signer intended. Just like if you remember even the Curtis against chemical dyeing, the woman who signed the document when being told that yes, the document that you have signed, the laundry company is limiting its liability only to the beads and sequence embossed on it. When, as a matter of fact, if you'll examine it, the document was actually supposed to completely exempt the company from any liability. And two, the signer was not careless in signing the document. Where the signer was not careless in signing the document, it can also enable the court to hold that the contract is void, as it were. But we know that the basic point is that where you've put your signature on a document or you've thumbprinted or anything, you are bound to, it's taken for granted that you are bound by what the document says. It does not matter whether you read it or you did not read it, either you understood it or you did not understand it as it were. And you know the well-known case of a Saunders against Angela Building Society. In Angela Building Society, an elderly widow, as you know, signed a document. She did not read it because she did not even have reading glasses and all that. But the court took the view that she could not benefit from the play of non-S factum because the mistake she made was not sufficiently serious. That is to say that she could not demonstrate that the document she signed is fundamentally different in character from what she intended to sign. And two, she had been careless. You know, you're an old woman. You cannot read unless you have your spectacles and all that. You decided not to do the needful and you just signed. And the House of Laws used the opportunity to restate the law that non-S factum is generally unavailable to someone who signs a document negligently or carelessly. And then two, a mistake as to identity of the person in whose favor the document is executed does not usually support the play of non-S factum unless the court deems the mistake fundamental. And three, the play may be upheld if the document signed is fundamentally different in character, in effect from what was intended to be signed. You know the case of Foster and McKinnon. So because of time, we will not belabor it, but the facts are similar to Sanders against Angela Building Society. And our case of Wilson and Broby, popular case we cite when we are talking about the non-S factum. And also Cow and Scory. So non-S factum, of course, has a stringent criteria, but we could by and large say that it protects individuals who did not sign a document where somebody has not signed a document, but through some dubious means, that document is being forced on him or her, you can successfully plead the non-est factum. It also protects illiterate or blind person who rely on others to explain the document. So there's what we call like that is why we have what we call like the jurat clause. So you've signed a document, you are illiterate or blind person, and then there's a jurat saying that before the document was signed or marked by you, it was plain and read in the language that you understand before you sign and so on. It may well be that that is not the case. So if you can lead evidence to contradict, let's say, the jurat clause, despite the fact that you have signed or made your thumbprint on it, you can escape from the effect of that document. And non-est factum should enable you to do that. Yeah, so definitely it will also apply to those who do not understand document due to illness, incapacity, or defective education. But in all this, of course, fraud, as we know, vitiate everything. But in all this, one thing we should remember is that the court will look at all the circumstances. So there are certain types of cases. It's not so much about going by the rules of thumb. The court will look at the peculiar configuration of facts and come to appropriate conclusion, as it were. Now we move on to misrepresentation. Misrepresentation, as we know, comes from representation and then the mix. But the point to remember is that when it comes to business transactions, it is common for people who are about to enter into contract to try and induce or entice the other party to be interested in going ahead to make the contract. So all manner of statements, all manner of assertions or representation may be made. And some of the statements made may relate to things which existed in the past, or things which are existing now, or things which will come into effect in future. Now, these statements, some may turn out to be false. That is untrue. Now, not all those statements will turn out to be untrue, for example, will be relevant for purposes of what we are going to discuss and misrepresentation. But for purposes of misrepresentation, we are talking about a false statement of facts. A statement of facts made to induce a person to enter into a contract, and that statement turns out to be false. So the crucial thing or the key characteristics to note is that for misrepresentation to arise, we must show that a statement of fact was made. A statement of fact was made. And the statement of fact, we're not talking about a statement of future intention, opinion, or law. So if someone made a statement of what he intends to do in future to you, and that persuaded you to enter into a contract, should it turn out to be false? Generally speaking, it may not be a basis for misrepresentation unless we can bring ourselves within the limited exception under Argentin and Fitzmaurice. Again, a statement of opinion or statement of law, if relied upon and turns out to be false, cannot give rise to misrepresentation. It is only a statement of fact. So, the second point to also notice that inducement is not enough that a statement of fact was made, which has turned out to be false. No. The other crucial element is inducement. Were you induced, were you influenced, were you persuaded by that false statement to enter into the contract? So these two elements are always crucial. You want to find out whether misrepresentation actually exists or not. And we have noted that as a general rule, opinions or statement of opinions are not actionable as misrepresentation unless they are presented as facts. So the case of a buy-set and vacancy is often cited someone made a statement regarding the number of sheep which a particular farm could support. I think the statement was that it could support rearing of 2,000 sheep, but it turned out that it could do far less than that. And subsequently, the statement that the farm could support 2,000 sheep was sealed upon. And the court said that an opinion regarding the land's capacity for sheep farm was not a misrepresentation. It was merely a statement of opinion and not a statement of fact. What about where fact is disguised as opinion? Sometimes you can disguise a fact as where you make a statement of opinion which is not supported by the underlying facts. Then, despite the fact that it's a statement of opinion, it will be treated as a statement of fact, as happened in the case of Smith against Land and House Property Corporation. As you remember, someone was selling a property and he had a certain tenant in the property. So he told the prospective purchaser that this certain tenant, Mr. Fleck, is a most desirable tenant. So the purchaser went ahead and bought the property without being worried by the fact that there was a certain tenant in the property. Now, subsequently, the purchaser had a serious problem as Mr. Fleck, the so-called most desirable tenant, had been turned out to be having arrears of rent and owing so many things relating to the property. So he sued the vendor regarding the statement that the certain tenant was a most desirable tenant. And the court held that the statement that Mr. Fleck was the most desirable tenant should be treated as a fact and not opinion, because the seller knew very well that Mr. Fleck had not been paying his tenant for a long time. So if you know a tenant who has not been paying his rent, how could you say that he is the most desirable tenant? Again, a statement of intent, that is statement of future intention, generally are not actionable unless there is evidence of fraudulent intent. In other words, as a general rule, if you make a statement that something will be done, that per se will not be treated as a statement which can give rise to misrepresentation. However, if there is evidence to show that at the time you made a statement that something was going to happen, you never had that intention, then as Blackburn said in Edington and Fitzmaurice, that the state of a person's digestion, right, in the stomach is as much a fact as to a state of what he says he will do. So Edington and Fitzmaurice, as you know, the company issued a prospectus to try and entice the public to invest in the company, and stated that they were going to use the money from the subscription to expand the business. But subsequently, they used the money to rather pay creditors of the company. So later on, when the company collapsed, the directors were sued for a false statement regarding how they were going to invest the money that they were raising. And the court said that that statement, despite the fact that it was a statement as to the future, could be treated on this occasion as a statement of fact that can give rise to actionable misrepresentation. And again, as a general rule, statement of law cannot give rise to misrepresentation unless it's a statement of a misfact and law, as we saw in the case of a Saul and Bacha. The Saul and Bacha, as you notice, there was this a confusion as to whether particular legislation, the Rent Act, was applicable to a certain property which had significantly been renovated. And the court said that that was a misstatement of fact and law, and that would give rise to, let's say, misrepresentation in appropriate circumstance. Now, there's also this issue as whether silence can give rise to misrepresentation is also an interesting examinable area. And the general rule is that silence does not constitute misrepresentation. And of course, we often say caveat emptor, let the buyer beware. That is to say that if you are going to enter into contract with someone, and then the person, for example, is silent about certain things, and for that matter, you assume that those things that he's silent about are true, but you later on discover that they are untrue. You cannot sue him for misrepresentation because silence cannot give rise to misrepresentation. But there are exceptions. There are instances in which a person remaining silent at the time of making a contract with another person can find himself being liable for misrepresentation. And what are those instances? One, misleading half-truths. What do you mean by misleading half-truths? When a party makes a statement which is true, right, but omits important information, you have said something which is true, but you also omit certain information, then that can, despite the fact that what you said on the face of it appears to be true, because you've omitted an important information, it will render what you have said misleading, and that can give rise to misrepresentation. As happened in the case of Nottingham patent breaks against Butler. And in that case, a solicitor statement that he was unaware of restrictive covenant was held misleading because he had not checked the relevant documents. Another exception to the rule that silence does not give rise to misrepresentation, or silence can give rise to misrepresentation, is change of circumstances. So here, you make a statement which was true at the time that you made it, but subsequently, circumstances change and you render the statement you previously made, which was true, false, and you don't update the other party about it. So your failure to update the other party about it can give rise to misrepresentation, as happened in the case of Flanagan that all of you know, where a defendant's failure to inform the buyer. Someone was selling his medical practice and he presented the earnings of the practice to convince the buyer that the practice was worth the purchase. But the information presented at the time was accurate. The doctor in charge fell sick for a long time, so the practice was not doing well. So eventually, when the sale was concluded, the figures were really bad. But he did not know, the seller did not tell the buyer about the change in circumstances. And subsequently, the court held that the failure to disclose the change in circumstances, the fact that the revenue had gone down due to the sickness of the main doctor in charge, rendered the earlier statement false, and that could give rise to misrepresentation. Also, when it comes to contract to Berma Fide, that is contract which require utmost good faith, there is obligation for you to make all material disclosures. All material factors or material facts should be disclosed. Otherwise, the failure to disclose any material facts will give rise to misrepresentation. So, contracts which require good faith or contract Berma Fide include insurance contracts, right? If you're going to take, let's say that life policy, you must disclose all material facts regarding any health conditions and so on, because all those things will enable the insurance company to decide whether they want to enter into that policy agreement with you or not. Also, when it comes to fiduciary relationship based upon trust and good faith, it is required that any contract within that relationship, there should be full disclosure by both parties. So such as solicitor-client relationship. A solicitor must disclose everything, a client must disclose everything. Principal-agent relationship. Now, where you do not disclose, that can give rise to misrepresentation. You've also talked about the fact that to have an actionable misrepresentation, there should be inducement. You should prove the element of what? Inducement. And that is to say that the representee, that is the person company of the representation, must prove that he was actually induced by the false statement. He was actually influenced, persuaded by the false statement to enter into the contract. So here we are talking about materiality. That is to say that the misrepresentation must be significant enough to influence the decision making of the representee to enter into the contract or not to enter into the contract. So if you take the case of Smith and Chadwick, which we have also mentioned earlier on, or if you have encountered it already, it illustrates that point. But then, where you have carried out your own independent investigation, that is to say that a statement of fact has been made to you, okay? But you decide to conduct your own investigation to verify the statements which have been made to you. Then, once you do your independent investigation, the original representor will no longer be liable for misrepresentation should it turn out that the statement or the representation is false, as happened in the case of Atwood and Small. As you remember, over there, somebody was trying to buy like the property and it got its own independent experts to verify various statements regarding the worth and the capacity of what they were buying. So later on, when it turned out that what they had been told was not true, that was giving rise to misrepresentation. But the court said that because they had used their independent experts, in that case, they had not satisfied the requirement of inducement or the materiality. Now, what about where you have other factors and not only the misrepresentation which influence the plaintiff? Can that give rise to actionable misrepresentation? Yes, the case of Argentina and Fitzmaurice suggests that yes, even if the misrepresentation was just one of the contributory factors, that can give rise to actionable misrepresentation. Also, where there was an opportunity for you to investigate, okay, but you declined, maybe the person made statements and he gave you the opportunity to go through the books or to come and inspect and do certain verification, but you declined the opportunity to verify the statements. Then later on, should you discover that those statements are false, that will still give rise to misrepresentation. So let us keep that in mind. As happened in the case of the Redgrave and the had. I mean, the solicitor who was selling his practice, and then the other party was given the opportunity to go through the books, but he declined to verify the accounts. Good. So these are the things which need to be established before we can have actionable misrepresentation. So what are the remedies? In other words, where you have established that, yes, misrepresentation existed because there was a false statement of fact, that false statement of fact when it induced the contract. What remedies are available to the victim of the misrepresentation? Well, there are two main remedies, rescission and damages. Rescission seeks to restore the parties to their pre-contractual position as if the contract had never been made. So that is the rescission as a remedy. And it is available to all types of misrepresentation, except that there are certain limitations, as it were. So one, affirmation. If the party misled, that is the person who is complaining of misrepresentation, after becoming aware of the misrepresentation, continues with the contract, the person will be deemed to have affirmed the contract and lose the right to rescind. So we take the case of Long and Lloyd, for example. The plaintiff had become aware of the misrepresentation, having discovered the Lorry's effect and so on. But the court said that the acceptance of a contribution towards repair costs was evidence that he was not prepared to seek a remedy for the representation, and he had already affirmed the contract. So in other words, if you become aware of the misrepresentation, you don't have to continue to observe the contract. If you continue to observe the contract, you'll be deemed to have affirmed the contract. And in law, we say that you cannot approbate and reprobate. You cannot say that, yes, I have extricated myself from this contract, and yet you are conducting your life according to the terms of that contract. No, that will be affirmation. So once you want to set up the misrepresentation, as soon as you become aware, you don't have to observe the contract again. Well, rescission may also not be available where there has been lapse of time. In other words, there has been a long period of time when you became aware of the misrepresentation and when you decided to actually act. As we see in the case of Leaf International Gallery, there was a delay of 5 years when the person discovered that the artwork was actually not done by the particular artist. But he waited 5 years before going to court. The court said that, well, 5 years was too long a time to be seeking to rescind a contract you claim is vitiated by misrepresentation. The fourth bar or the fourth impediment to availability of rescission is where there's impossibility of restitution. The idea of rescission is to restore the parties to the status quo ante, that the position they were before the contract was made. We call that restitution. So where restitution is not possible, where the subject matter of the contract is said that it has been consumed or fundamentally altered, so that we cannot take the parties to a position that they were before the contract was made, then rescission is not available. Rescission is not possible. And you can cite the case of Clark and then Dixon. Of course, where there have been intervention of third-party rights, rescission is also not possible. And typically, just like the Phillips and Brooks, those situations where, yes, there's a clear case in which rescission could be given, but the fact is that innocent third parties who cannot be blamed for whatever has happened have legitimately acquired a legal interest in that contract, which is affected by the misrepresentation. Then the rescission will not be available. Damages, which is monetary compensation, may also be awarded for misrepresentation at common law. Now, in Ghana, we don't have the misrepresentation legislation, but we go to the UK, they have the misrepresentation legislation of 1967, which provides the framework for when you can get rescission in lieu of damages, or when you can get both rescission and damages. But that is not part of our laws. We shouldn't worry ahead about it at this stage. Good. So we look at the types of misrepresentation quickly before we finish. Yeah. So we have fraudulent misrepresentation, and fraudulent misrepresentation is where a person makes a false statement of facts with intention of deceiving another party, knowing that the statement is false or is being reckless as whether it is true or false. So as you know, the case of Dairy and Pig, Lord Herschel's famous rendition, what I have just paraphrased here. So the point about fraudulent misrepresentation is that the maker of the statement made it knowing that it is false, or he did not care whether it was false or true and made it. So the key elements, false statement of fact. The maker of the statement had knowledge of its falsity. Third, the maker of the statement made it with intention to deceive the other party to whom the statement was made. And finally, the other party to whom the statement was made was induced by it or relied upon it. And remember the case of a Dairy and Pig, so we will not belabor that point. The remedies for fraudulent misrepresentation are essentially what we have discussed, so we'll not belabor it. Now, innocent misrepresentation occurs when one party to a contract makes a false statement of facts that induces another party to enter into the contract, but the statement is made honestly and without any intention to deceive. So there is no what do you call the main important distinction between fraudulent misrepresentation and innocent misrepresentation is that in the case of the fraudulent, the maker of the false statement made it with intention to deceive, right? And he knew that what he was saying was false. But in the case of innocent misrepresentation, the maker of the false statement made it in all honesty. That is to say that he didn't know that it was false. And he also did not have intention to deceive the other party, the representee, as it were. So let us keep that in mind. The negligent misrepresentation is where a party makes a false statement carelessly or without reasonable grounds for believing it to be true. And the statement induces another party to enter into the contract. So this negligent misrepresentation is relatively little in time as far as this area of the law is concerned, going back to the case of Headley Brand against Lane Partners in the 1960s. And the idea is that where there's a special relationship between the maker and then the recipient of the statement, then the maker of the statement owes a duty of care to the representee or the other party to ensure that the statement that is making is not false. So he has to exercise that duty of care to make sure that he's telling the truth to the other party. But where the other party who owes the special, who has a special relationship with the representative, for example, makes the statement without exercising the reasonable care to ensure its accuracy, then you have breached the duty of care. And if the representative, that is the plaintiff, relied upon that statement and actually suffers a loss or injury, you'll be able to bring an action in misrepresentation. That's happened in Headley Brand and also Petroleum. But I must say that Headley Brand against Headley and Partners, as you know, it would have been a perfect case for misrepresentation and negligent misrepresentation, but there was a disclaimer, meaning that those who provided the financial statement and financial advice, having given the opinion, put in a disclaimer that they are not prepared to accept responsibility for any reliance which is placed on it. So if it had not been for that disclaimer, then negligent misrepresentation will be made out in Headley Brand against Headley and Partners. On the other hand, in Essay Petroleum against Madden, it was a sale of a petrol station, and the sellers made false statements regarding the potential sale of the petrol station, in the sense that they didn't exercise the requisite care by looking at all the available records and all that. And the purchaser bought it on basis of these statements and suffered losses. And the court held that the seller owed the duty of care due to its expertise to ensure that the statement it made regarding the potential sales of petrol station was accurate. So where, of course, where it is, you make a good case for negligence representation, you can also get the remedies which are available for misrepresentation, as we have discussed. But just before we go, I have this thing I want to show you. So in terms of comparative overview, as this is, I don't know if you can see, but let's do your best and see what is there. Let's see. Okay, so we have like the fraudulent misrepresentation in terms of its false statement made only without belief in its truth or recklessly. So available remedies, rescission and damages. And the damages here for fraudulent misrepresentation will include all losses directly resulting from the misrepresentation. Then we also have negligent misrepresentation. The definition here, false statement made carelessly or without a reasonable grounds for belief in its truth. And the remedy available is the rescission and damages, but the damages for negligent misrepresentation here is limited to foreseeable losses, not all losses. So that's the difference between that and fraudulent misrepresentation. And innocent misrepresentation, false statement made honestly and with reasonable grounds for belief in its truth. So that is reasonable, innocent misrepresentation, and the remedy available here is only rescission. Because at common law, no damages will be awarded for innocent misrepresentation. But as I said, the Misrepresentation Act of 1967 in UK does not apply to Ghana. So we don't have to worry our heads about that. Any question before we move on? I think I'm tired, so I'll come back in the evening and we continue this and do some other areas of the law as well. But if you have any question, I will take it before I leave you. So you can use the chat box. If there's anything you want me to look at, we look at it before. I don't see anything in the chat box, so I presume there is nothing. So I will come back a few hours and then we'll continue. Right. Have a good afternoon.